Okay. Good morning. Happy Friday.
Happy
Thank,
Friday.
Happy Friday. Thank you so much for being on the call. All right. Well, let's go ahead and get started. Again, my name is Simon Cazares. I am the team leader and also the broker for the KW South Bay office, the Long Beach office as well, and the Valley office as well. So we're going to go into the the process of closing the deal. The exciting part of what we do and the ins and outs of all of the documentations preparing for the actual closing of the transaction. There's a lot of moving parts when it comes to the end of the process. We're going to talk a little bit about the verification of property condition, better known as the VP. We're going to talk about the settlement procedure as well, how that can impact your client's position, right? And the importance for us as real estate professionals to make sure that they're updated on a consistent basis before it closes to make sure that all of the numbers and figures align. Okay. So let's go into part of what we do. Okay. So in essence, the verification of property condition, all right, is part of the process. And I'm going to show you when when you have the RPA, the residential purchase agreement, okay, the understanding of the language. So let me pull up the RPA first and foremost. Okay. Let me admit some people in. Give me 1 second, please. And let's go to the section of the final verification on the RPA. Because I think it's important and vital to understand the initial process. There's a lot of language and information when it comes to your understanding of the purchase agreement. And part of the process is that the buyer has the belief and understanding that within five days prior, 5 days prior of closing the deal, that the buyer has the right and the ability to do what's called a final inspection of the property. Okay. But I want to reference it because I think it's very, very crucial and important that it is not a contingent or condition of the sale, but it's just really to make sure that the property is still in the same original condition as originally submitted an offer. Okay. So on section 16 of the residential purchase agreement, it references final verification of condition. Okay. And it says the following: buyer shall have the right to make a final verification of the property's condition within the time specified in paragraph 3J. Not as a condition, contingency of the sale, but solely to confirm, one, the property is maintained in pursuit to paragraph 7B. Two, repairs have been completed as agreed. And number three, seller has complied with seller's other obligations under this agreement, CAR Form VP. Okay? So now if you look at the broader scope of this statement, it it entails the position that the buyer has the right to do a final check-in of the property. The buyer in the beginning looks at a property, falls in love with the home, submits an offer, you're in negotiations, and now your offer gets accepted. You go into your due diligence period, right? Now the buyer can do any and all inspections with the time specified, right? which is usually as defaulted 17 days. Okay. During that time, the buyer can ask what's called for repair requests, right? I am asking for the seller to repair, replace, give me credit in lieu of repairs, or give me a price reduction. Okay. So for the sake of today's class, let's say that the seller has agreed to repair or replace certain things that the buyer requested, and that was agreed upon. Okay. So this language specifies the reason behind that. Okay. That the buyer has the right to do so. Okay. But it's not a contingency. We cannot go back and say, well, I decided to cancel because this wasn't taken care of.
Shit.
Okay. Please make sure to mute yourself if you're on Zoom, please. Let me hold on one second. Let me go ahead and do it myself. All right. Does everyone on Zoom hear me okay?
Yes.
Okay, thank you.
Yes, for me.
All right, so not a contingency of the sale. So you can't say, I'm going to cancel because this wasn't taken care of, this wasn't repaired, right? There's recall scenarios that ultimately you can go after if something hasn't been taken care of, but it's not canceling and thinking that the buyer can retain their earnest deposit, okay? Because at this point in time, folks, the buyer has already, the assumption is that the buyer has already released any and all contingencies. Any and all contingencies, right? But this is a verification of that point in time that the buyer wants to make sure that what the seller agreed to do so is taken care of. So that's your time for your buyer and yourself to go and evaluate the home. But it also emphasizes the importance that the property is still in the maintained the same way as you originally saw the property. So let's go into now section 3J and see what that says. So 3J, we go back up. Three J. Okay. And it says 3J, final verification of condition, 5 days prior to close of escrow. Okay. It doesn't say it in paragraph 16, but it says it here on the grid. That means that within 5 days of COE, the buyer has the ability to go do a final walkthrough of the property. It's a requirement. The seller cannot, and I'll repeat it again, the seller cannot decline this request. Well, you already saw the property. You had 17 days to do so. Okay, you can't, and we will not allow you to go and do a final walkthrough of the property. Baloney. Okay. This is part of the condition. This is part of the process, ladies and gentlemen. So the buyer does have the ability to do so. Okay. Now, it's not something that a lot of people talk about. Okay, we talk about the greatness of these offers and negotiations, but it's very far and few that we really talk about the end of the transaction. The most exciting part of it is getting the deal closed, officially recording, transfer of title, and then providing your clients with the keys to their beautiful home, right? Or a home. But we don't really talk about this stuff, okay? And I'm dealing with one of our agents in the office that is similar to a situation, and I'll give you that case in a bit. But I want to stress the importance that that number is a default number, okay? It can be modified, and it can be negotiated between both buyer and the seller. Just because it says 5 days doesn't have to be 5 days. Now, that's why you have that little blank space right there. What does that mean? That means you can go more days or less days. I think 5 days is pretty reasonable in my opinion, but you can say, no, 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 I want a little bit more time. I just want to play it safe. Okay. Now, let me ask you this question. If it says that final verification of condition 5 days prior to close of escrow, does that mean that it's only one time to go and finally look at the property? Or does that give you more time to see if there's any other concerns that maybe you want to do a second or a third or a fourth within that time frame? Do you believe that it's only a one-time thing, or you can do multiple views and conditions of the property? Okay. How many say multiple times? Okay. Okay, we got a couple of hands here. How many believe that it's only a one-time deal? You go and check and you're done, and that's it. And the seller can decline you from seeing it again. Okay. Good. Okay. It really depends on the situation. There's no right or wrong to that. Now, typically, most times it's a one-time deal. They go in there, they'll spend several hours, and they're either satisfied, right? But let's just say that you do your final verification and the buyer had requested for the electrical panel to be replaced, and it was done. The electrical panel was done. You go there, you check it out, it looks brand new, everything looks fine, but then you start turning on the lights. And then in the hallway, the light does not turn on. And you go back, maybe it was an error on my part, maybe I had it off and I forgot to put it back on, and you check and it's on, and then you go back to the hallway and the thing is not working. Okay. The assumption, the assumption is probably the light, but what if it's recessed lights, right? Ooh, Houston, we have a problem, right? So is that something that you're going to put in your VP?
Yes.
Absolutely, yeah. You're going to put that as part of your verification. There's something wrong. And we want to alert the listing agent and the seller that this is not working properly. So I'm going to document that on my VP, and I'm going to call the listing agent. Hey, we have a situation here. In most cases, sometimes the listing agent may be there with you as well. I've seen, and it's very customary, where a listing agent is actually there with the final verification. Why? So we're all on the same page. If there's any issues or any concerns, we can address it right then and then. So if you're the listing agent, I would encourage you that you should be there with the buyer and the buyer's agent. Okay, make sure that the agent is there too as well, right? If there's something that is not working, hold that thought for a minute on Zoom. If something is not working, then you can address it right then and then that that was part of the request and we have an issue. And that could be an easy fix. Maybe the fuse is damaged and it needs to be replaced. They need to pull that one and put a new one and problem solved, right? But this is the whole purpose of having a final verification of the overall condition of the property. Okay. So hold that thought 1 second. So this is why it's very important for you to do that, because you don't want to close the deal and now all of these items were not taken care of or were not done in satisfaction to the buyer. And now we have a claim or a potential lawsuit, right? So we want to avoid all that. And this is why it's crucial and important that you and your clients are doing the necessary steps to make sure that the buyer's happy with the home, right? So we'll go with the question on Zoom. Someone had a question?
Yes, Simon, I just wanted to ask you, what if it's something that you cannot determine directly, like something that's not so visible, such as a structural or foundational thing? How do
Yeah.
you confirm that it's been done?
Yeah, you're gonna want to get your contractor out there. So if it's something significant, let's say for example that part of the request of repairs was it's on a raised foundation. The home is on a raised foundations, but it needed to be clamped and anchored to the foundation, right? Those earthquake safety anchors, right, where it clamps to the concrete and the actual house, and that was part of the request. And then you go there, you're not going to crawl, your buyer's not going to crawl under the crawl space, right? That's the opportunity to get your contractor or someone reliable to go and verify that that was done. That person is the expert. They'll go underneath the home, as an example, and will check to make sure that the property is secure. They'll take photos, they may take a video and say, boom, this is what we see. Most properties may have a crawl space too as well, where it may be from the inside of the house has some stairs, and now you can do a visual inspection, maybe with a flashlight, and can see that the house is bolted for earthquake measures. But it's common for a contractor or someone that specializes to have them come at that point in time. Maybe it's a plumbing, maybe it's roof, right? Maybe you can get a roofer out there and make sure that the roof was done in satisfaction, right? And the integrity of it. So that's when you want to get the professional help to make sure that it was done properly. And if not, then the individual that is doing the inspection with you can provide you with their findings. And then those findings now you can now relay through the verification document, the VP. Does that answer your question? Christine
Yes,
says,
thank you.
Christine, yeah, thank you. Christine says, get the receipt and have all parties sign an acknowledgement. 100%. Yeah. Anything and everything to secure and position yourself is always vital and important. Okay. Question here.
At that point, so say you keep it the same scenario, you request for a new panel update, right? Electricity panel update, and say they do the update on the panel, but whatever, say the wiring of the housing and the electrical and all, some of the stuff is a lot more than what it is, then something simple, and the buyer, get it fixed, or is the seller decline it and like.
Well, it really depends. And let's go back. Was this a request from the buyer? That the buyer was requesting that the panel be replaced? Okay. And the seller acknowledged and accepted to replace the panel as an example, right? And now the buyer is doing their final walkthrough, right? And there's some issues with the panel, you're saying?
No, the wiring of the whole house at that point.
Well, here's my concern with that. Anything to do with electrical, you want to get a licensed contractor, right? One that knows. And when you're doing something that significant, you're probably going to need permits by the city, right? Because the city is also going to need to know that it was done properly, right? So when it comes to those type of situations, you as a buyer's agent really need to define that as part of the request, not just, hey, replace the electrical panel, but emphasize and stress, to be done with a licensed, bonded, insured contractor, and also that permits will be given as well. Because sellers will be sellers. They'll try to find a easy way. And there's a lot of people that know how to replace it without a license. But if this issue down the line comes back, what do you think they're going to blame? They're going to blame the seller. They're going to blame the agents involved, because the agent that represented the buyer says, well, you should have known. You should have told me that I needed to do X, Y, and Z, or ABC as an example, right? So those type of situations, it's crucial, right? Something minor, replacing a dishwasher, you don't need a contractor, a handyman can do so. Uh, outlets as well, something minor, but something significant, then yeah, you want to get the right professionals to do so. And you wanted to make sure that it is by a licensed individual that's bonded. And then anything of that significance, then you also want to get a permits for it as well. That just gives peace of mind to the buyer, because remember, we're also looking at the future. If that buyer decides to sell the property, right, they're also going to transfer this information to the new buyer. Make sense?
Yeah.
Question? Yes, sir.
Something breaks that wasn't on the.
Good question. Yeah, good question. Okay, so
What was the question? We didn't hear
so
it.
the question is that let's just say that I submitted a request of repairs and the seller says, I'll take care of it. I'm going to repair some of the stuff, but I'm going to give you credit. And now when you do the final verification, you find out there's something wrong with the property, something wrong with the property. Yeah, that was not part of the agreement. Okay. And now you as the buyer's agent and the buyer are there, and now that's an issue. And remember, the buyer has released all contingencies already, right? So therefore, that brings up another issue. Because now you're doing your verification of final walkthrough, and now something happened that was working before and it's not working now. What do you do in those scenarios? All right, before we go into that conversation, I'm going to go back to the VP. Okay, so let me go back to the VP. And let's see what the verification of property stipulates. So it says the following. Tells you the property address, and it says 1A, 1B, and C says the following. The purpose of this inspection is to satisfy the buyer regarding the condition of the property. Satisfy the buyer regarding the condition of the property. What does that mean? Yeah. Yeah, that the buyer is completely satisfied with the condition of the property. Unless otherwise agreed, buyer and seller understand and agree that a final inspection is not a contingency of this agreement. The verification of property or its waiver is not intended in any way to alter the contractual obligations of the seller regarding the condition. Okay? Meaning the intent, right, in any way, shape, or form is to alter the contractual obligation is, regardless of what the agreement we agreed to, this is something totally different. We want to make sure that what we saw the property is still in the same condition. Condition of the product to be delivered to the buyer at possession date and is not based upon any statement or representation by broker, associate license, or brokerage's employees. C, the parties agree to hold broker, associate license, and broker employees harmless from any liability, claims, demands, damages, or costs arising out of the contractor obligation of buyer and seller concerning the condition of the property. Let me repeat that one more time. The parties agree to hold broker, associate license, and brokerage employees harmless from any liability, claims, demands, damages, or costs arising out of the contractor obligation of buyer and seller concerning the condition of the property. Buyer acknowledges the property is in the substantial the same condition as on the date of acceptance of the offer to purchase, sell, and seller has completed any repairs, alterations, replacements, modification as agreed to by the buyer and seller with the following exceptions. Okay. What does that mean to any of you? What does that say? Anyone?
things, like, we got to do this, we got to get inspection, we're here.
Yeah.
So we are supposed to negotiate to get it fixed, of course, but.
Well, remember, who still owns the property? The seller still owns. Is the seller still responsible? 100%. If the house catches on fire, who's responsible? The seller is, right? They're still owners of the property. Okay. Now, Steve says here, I have found that whatever possible as a listing agent, I always try to get buyer and seller to agreed upon seller giving the credit rather than seller actually repairing, replacing. It eliminates the headaches at walkthrough of repairs not being sufficient. 100%. Thank you, Steve. Yeah. You know, the best direction is always give money, right? Throw money, right? I don't, especially if your clients are elderly, right? They don't want to deal with repairs and replacements. They'd rather just throw the money and be done and let the buyer take care of it. So, good point on that from Steve. Absolutely. You know, I would encourage if it's a laundry of items that the buyer's requesting, yeah. In lieu of the repairs, I'm just going to throw money and let the buyer take care of it because they may have a handyman, they may have a contractor, they may want things done differently. And that's okay. They're going to own the property at the end of the day, right? Let it be. So, yeah, I would probably go in that same direction. But in these situations where the seller is adamant, you know, he thinks, she thinks, they think they can get it cheaper, they rather do it themselves and get it replaced. That's all good. That's part of the beautiful thing of negotiations. Absolutely. But when it comes to a dispute, as you were saying earlier, what if something that was not agreed upon happens to the property? Okay, what is the situation there? Can the seller say, well, you released all contingencies, property sold in his as is condition, right? It's not my problem anymore. That's going to be your problem, right? Is that a reason for the buyer to cancel escrow? And is that a reason for the buyer to also get their full deposit back? No. No, it's not. Okay. Now, in looking at all of the situations regarding this, right? Do the right thing. Okay. Now, let's just say it's a significant situation, right? And then let's go with a minor situation. They notice that the kitchen sink has water. And we're assuming that it's probably clogged, right? And we do our final walkthrough, we put that on our VP and we call the listing agent, or if the listing agent's there, hey, look, this is who's responsible to unclog it? Is the seller responsible to unclog it? Is it the buyer's responsibility now? Because the seller, let's just say that the seller never lived in the property or has already moved out of the property. Who is responsible for that? Okay. Okay. How many people say it's the seller's responsibility? Okay. A handful of you. How many say that it's the buyer's responsibility now? How many people don't know? It's a situation where it's all about communication, folks, okay? Absolutely, it's the seller's responsibility. They still own the darn property, guys. Now, you know, the buyer may argue their position is, hey, you know what, I'm gonna hold off and delay of closing this because this is a significant situation. And they can argue that. Remember, this can go either way. Now, I wouldn't encourage, you know, to hold off on closing, especially don't be that agent that waits one day prior to closing to do your final verification. Get it done. The sooner the better, because if there is an issue, you can now nip it by having dialogue with the listing agent. Because now you still have 5 days before the deal closes. So if you know it's closing next Friday, get it done this weekend. Make sure that everything is good. And if not, that gives you the buffer and time frame to make any type of arrangements like that clogged sink, right? I would say, hey, you know what, we got a clogged sink, we tried everything, but it's still clogged, we may have to get a plumber out there. Well, the seller should be responsible to do so, right? Because that's not how it was before. Okay? So don't be that agent that waits one day before it's about to record and let's go do the final walkthrough, because if there's a big significant issue and it's set for recording, it may be too late to stop or delay the process. Now the problem will escalate. The deal transfers ownership. The buyer is now in possession of the property. Then the likelihood what they can do is file a lawsuit against the seller. Okay. And that's still an uphill battle. There's no guarantee that the buyer's going to win. But documenting everything is crucial and important. Question.
Yep. So practically speaking, if you go the day before, it's supposed to close, but you can't get the garage door to work.
Yeah.
Just tell the other agent, say, hey, the garage door's not working, you gotta deal with this. Maybe you just can't figure out how to work the garage door. You know what I mean?
Well, it could be a couple of things. Yeah, maybe you don't know how to work the remote control, because I've been in situations where you got to do certain things to make it work. Or sometimes, like a garage door has sensors, and there may be something blocking it, and this is the reason it's not allowing it to open or close. So maybe visually look at the garage and make sure that everything's aligned. Because I've seen it happen to my property. The sensors were off; they were off alignment. So I kept pressing, it kept not opening. So I went there, I evaluated, fixed it, aligned it, and everything was working properly. You just never know. You just never know, right? So going back to significant problems, right? Let's say that the buyer has released all contingencies. And now we're at the final stage of verification of the condition of the property. And now what was agreed upon has been taken care of, but now we have something else. We see something significant. Let's say that the floor, as an example, on a raised foundation, and you step on it, and now it feels really weird. And you didn't notice that before. And now you're thinking, oh, maybe it's sinking, right? And there's houses that have certain sections where it's uneven, where you can actually see it that it's leaning, right? What do you do in those circumstances, right? How do you handle that? Okay. I think it may be too late in those circumstances, you know? That's something that should have probably been caught during your inspection contingency period, right? This is why you want to get a thorough inspection done on the property. And a thorough inspection is a good company that will check everything, will crawl underneath the house if need be, will go on top of the roof if need be, right? Inside the attic to make sure that the integrity of the property, right? And if home inspection is not enough, then you can get experts, right, that can go up to the roof. Experts that can go underneath and look at the plumbing or the foundation or the structure of the home, right? Because you want to make sure that the buyer is satisfied with the condition of the home, okay? But you cannot claim it after the fact when the buyer has released all contingencies. So you want to do it within the time frame because that's your shield. That's your protection. That gives you the decision to move forward or to cancel the deal if the seller doesn't agree to it, right? But here is, and this is why it's important, and you got to be active on this, is that this part of it is just the verification of what you requested and the seller has acknowledged and accepted the terms and that the property is what you guys agreed to. And that's where you put all this information. And if everything is within satisfaction, you can leave this completely blank and have your client sign at the bottom. If there's still some issues, then you want to address it and put it here as follow. Sometimes I've seen VPs where they say there's a lot of trash still left here. The garage is a disaster. The bedrooms have all kinds of stuff still. Note it on there. Document it, right? Because that's not the intent, right? Now, if the seller and the listing agent originally said there's going to be personal items still left at close of escrow and you agree to it, then you cannot complain about it. But if that was not what was agreed upon, then the house should be in decent and in clean conditions with no personal items or more so any trash. Now, only the trash that is common, right? When some people move, they're going to have, trash. I've bought in properties that have tons of trash, but I know what I'm getting myself into, right? But usually when it's a buyer and a seller deal, you want to emphasize the stress. And on the contract, it tells that an understanding that the seller must leave the property clean with no personal items and trash, picked up as well. Because that's an argument, and that can be an argument that I can throw as a buyer saying, well, I'll get someone to come and throw this. It's going to cost me $500. I'm gonna send an invoice to the listing agent and the buyer to pay me back. Because that's not my responsibility. Remember, the dynamics and the beauty of what we do in real estate is things can be altered, modified. Okay. If there's not a meeting of the mind or there's a disagreement, then we want to make sure that we document it as well. Does that make sense? All right, we have a couple of questions on the chat. Let's see. Christine says, Simon, can you repeat the audience question? Okay, so I think the question was in the back. It was regarding the garage. So the question was, what if the final verification, the garage is not working? And that was not part of the agreement. What do we do then? Well, again, common sense is bring it to the listing agent and the seller's attention, right? You can either call, or if the listing agent is there, you're going to say, hey, what's going on with the garage? The garage was working when the inspection was done. Everything was working now, and it's not working now. What do we need to do to take care of it? Okay, no worries. Let me make sure we can get the seller to address it, right? And then the seller can go and get a garage door person to come out and evaluate the situation. Maybe there's, when they move, they accidentally move again the sensors. So that was kind of the question was about the garage and what happens with those type of repairs.
Who's responsible?
The seller's still responsible. Yeah. Yeah. Why is it the buyer's responsibility to fix someone else's garage when it's not even their home yet?
Yeah.
Now, again, looking at the big picture, right? Depends on the circumstances, right? Now, if you piss off the listing agent and you pissed off the seller, they may go pound sand. And I've seen situations like that. Now you're opening up a can of worms of issues, right? You're opening up a possible litigation. They may want to sue, and they have the right to go to small claims if it's minor. Do you want to get dragged into court now, spend time, and your case may not be the first one, so you may be all day at the court waiting until your case is heard, and then you got to go in front of the judge, and you got all these people listening. The plaintiff is saying their stuff, you as defendant are saying your stuff with no guarantee that you're going to win the case. And if you don't, there may be monetary costs or replacement after the fact. So think of it this way, be proactive, meaning that if something is not working and it's not your home yet, then it falls back on the seller to take care of it or to come to some type of agreement. Because let's say, for example, it's a wall, right? A sidewall, neighbor wall, right? It's shared by two neighbors. And when you submitted an offer, the wall was intact. When you do your final walkthrough, the wall is collapsed. Holy crap. Now what? What happens then? What do we do? You think that the seller is going to want to spend $10, $15, $20,000 to replace the wall? I don't know. Think of that scenario. What if that happens? Well, it may be an old wall that was deteriorating for years and years and years, and something happened and it collapsed. Now, that's a worst case scenario, right? A wall falls, who is responsible? Well, the seller's responsible. But imagine this, okay? Imagine that this is, you're about to close this deal. And 2 days prior, you do your final walkthrough. And then when you do your final walkthrough, you realize that the wall is down now. Well, first you got to find someone that knows how to do the wall, and the deal's about to close. You may want to delay. You could. You have a reasonable position to say, look, we're going to have to delay this because I'm not going to be responsible to fix this. This is your property. You're responsible. It happened while you still own the property. So we're going to ask for an extension. And that's a good argument to say. Or the seller can says, look, I need to close. I already bought my other property. There's no way we're going to be able to delay this. I need to close. So I'll give you money to repair it. Let's get at least 2 quotes and see who's the best one. And then the seller as part of the seller's concessions, excuse me, that's concessions, seller's proceeds, they may put aside, $10,000, $15,000. I don't know. Or the seller can say, it's not my problem anymore. It's your problem.
What if there's warranty?
If there's what?
Warranty?
That's a pre-existing situation. I don't think warranty is going to be able to take care of it because we already know of it. The owner still owns the property. That's not going to fall under the warranty on the buyer. So therefore, I can tell you it's not going to be covered under warranty. So is there an addendum to delay closing until repairs are done? So absolutely, you can use if you need to, and these are great questions, by the way. If you need to delay from closing and everyone's on the same page, then you definitely want to do the extension time addendum, extending the time to close, and instructing escrow that we're not going to close on Tuesday. We're literally going to try to push it for the following week if necessary, right, as a buffer. And as both parties agree to it, then yeah, escrow will be instructed to extend escrow from closing. The lender needs to know, and then we could go. And yes, you can do an addendum on that case. Okay. Or the alternative is not to extend, close the deal, and part of the instruction on an addendum, the buyer's requesting the seller to provide 15,000, 10, or 5,000, 3,000, whatever the amount is, to be held in escrow until the seller, finds someone to do the repairs, or give credit to the buyer, right? Give that money to the buyer, so the buyer then would be responsible to take care of that obligation. Does that make sense? Again, so many scenarios. I don't have the answer to any of them because I can tell you it's going to go this way and it never does. So it's case by case, folks. It's literally case by case. If you got great sellers and great buyers and they work together, beautiful. Because the seller knows, look, I own the property. I need to take ownership to that. But if you've had a bad experience through the process, the seller may say, go pound sand, you take care of it. That opens up a can of worms and a potential lawsuit. And you got to be mentally, physically, and emotionally prepared for that as well. Because if both are duking it out, meaning the buyer and the seller, then you got a dispute. Now, our job is to help navigate it, but it's not our job to tell them what direction they need to go. We can advise them and tell them, look, it can go this way, it can go that way, but you, Mr. Buyer, you, Mr. Seller, need to tell me what direction you want to go with this. Does that make sense? Okay. All right. Does that hopefully answer your question?
Yes, thank you.
Okay. Simon, I'm doing a final walkthrough on Sunday. What do I put here in the section 2B after the following exception? So 2B. Let's see. 2B. So you're referring to seller has completed any repairs, alteration. Is that the section you're talking about? Modification is agreed by buyer and seller with the following exceptions. Okay. So
Yeah, the one right under that, Simon.
were all the lines, correct?
That is correct, yeah. Well, the
Okay.
one under that.
All right. So if there is no issues with the property, none whatsoever, nothing,
Mhm.
you can leave it blank. And then just have your client sign.
Okay.
Okay.
Where's
So
the issue?
if the property, and remember, you got to look at it from two sides, right? One side is if the buyer never requested anything to be repaired and they gave you credit, then, and there's nothing of significant concerns, then you can put nothing to report or just
Mhm.
completely blank and then just have the buyers acknowledge that they did get the copy of the final verification, but there was nothing for them to, put down.
Okay, so I did release the contingencies. Um, only thing that my buyer told me was that the garage door opener uh, is not catching. But I fixed it when I went over there myself. The guy's not very handy. It just needed the chain retractor needed to be pulled. I fixed it myself, but me and the inspector
There you
were
go.
there, and we were playing with it, and that's what the problem was. But I guess when my buyer and his wife went over there, they pushed it and it didn't latch on again. So it's a simple fix, but I did mention it. But I just wanted to know what was that other there it says the evaluation of the condition property, including the above listed. Is this
Yeah.
what is
Well,
that? What do I put there?
I haven't talked about it. You're 2 steps ahead of me still.
Okay, all right.
Okay, so funny you said that. It's something that we were just talking about a garage.
Mm-hmm.
So again, those situations can happen, right? Now, yes, you definitely want to bring it to the client's attention, the listing agent and the seller, because it can be more than just it came off the chain, right?
Yeah.
Or the sensors are not aligned. It may be something significant, right? Um, but remember, at the end of the day, you're buying a used home typically, right? It's not going to be 100% brand spanking new. And even brand new construction homes, guess what? There's going to be issues with it as well. All I'm saying is be prepared for whatever comes your way, right? But if it's something of severe significance and concern to the buyer, you want to definitely address it on the final verification or walkthrough. And part of it is documented on this form. Then relaying that information to the listing agent. Hey, just wanted to bring you to attention. When my clients were there doing their final walkthrough, when we were, I should say, we noticed that the garage door would open, and then when it would close, it would uh, not securely, but it would fall off the rails or whatever the case. And then I just had a nudge. Can maybe the seller look into and evaluate if this can be something that they can fix, Depending on the circumstances, the seller can say, yeah, you know what, I'll take ownership, I'll get someone to go out there. If it was me as a homeowner, I would want to give a home to a new buyer. They're buying my property. I want it to at least be in working order, right? It's like you selling a used car. Can you give a car that is trash, dirty, and not in the best condition and has some issues? You could, but as long as you disclose all that, right? but you want to do the best when someone buys something from you, clean up the car, pressure wash the engine, armor all the tires, and make it look impressed, right? That you took pride of ownership on it when the next person now takes pride of ownership to that vehicle, right? Which should be the same thing with your home. Does issues and circumstances happen? Absolutely. Does it happen always at the very end when the deal's about to close? All the time. But it's our job to be able to navigate the conversation and try to make a win from it at the end. I don't know the answer to all of the questions because, again, I'm not the seller, I'm not the buyer. So I don't know what their intent is. If they're going to do it, great. And if they're not, great. I'm just going to relay this information and see what the buyer decides to do or what the seller decides to do. We have no control over that, folks. Does that make sense? But we can explain the pros and cons and the outcome if they don't, right? Well, the buyer may come after and try to sue. So if you're okay with that and you're ready to spend a whole day at court, then don't do anything. Okay, that's on you, not on me, but it's on you. Because we can't force anyone to do anything, right? We can't. So going back to your question, it really depends. The last part of it is the evaluation of the condition of the property, including items listed above, is based upon a personal verification of the property by buyer or agent performed on date and data so, and test survey inspections and other studies performed by the inspector. So that section there is basically if anyone else is evaluating on behalf of the buyer. So if you as an agent is there or you have a contractor that is evaluating, let's say the pool, the plumbing, the roof, the electrical, right? Anything, and you have someone else doing it, then they're going to evaluate it and you're going to put who was the person that did and performed that. And what date and time was that done, right? If it was a test, right? Let's just say that a air quality test in the basement was done as an example, and before there was no humidifier, right? One that sucks up moisture, but then the seller, in good faith, installed or repaired or replaced a new system that now clears up, and now you have someone that goes and tests the moisture. Then you can have a company do that. You're going to put the company's information or the person that did the that inspection. Make sense? All right, so Christine, you have last question. I have had an issue in the past when the VP was finished, but the seller in possession in place, and upon furniture being removed, surprises appear, like desk cover, not existing hardware floor space in the middle of the room. It was a shocker. Okay, good point, good question. Her question is, what if the seller, right? And we'll finish with this topic because I think it'll take us right into 11:30. So let's just say you're the buyer's agent. You're still going to do your final verification prior to close of escrow, because I get this quite often. Simon, should we do the VP after the seller leaves the premises? Because sometimes the seller will stay after close of escrow for maybe a couple days, maybe a couple weeks, or maybe a month or so, right? That's where the SIP comes in, seller in possession after close of escrow. And they'll say, well, maybe we should do the VP after the seller leaves. That is not the intent for that form. The intent for that form, if you read it, is 5 days prior to close of escrow. So in essence, you still do your VP 5 days prior or within the time frame. Okay. Now the question here, and it's a good point, Christine, thank you very much for sharing, is what if the seller stays and there was furniture when you did the final walkthrough, right? Just like this training room as an example, right? There's furniture in here. But let's say that if we were to pull the white board and pull the KW sign, and on back we see a big hole that we didn't see before, right? That is her claim. What happens? What do we do in those circumstances when now the seller has vacated the property? Well, if you look at the seller in possession, the SIP form, there's specific language in there that says, you know, what happens if there is concerns or issues. Remember, everything that we do is all negotiations. And we are assuming that the property is given to us in a overall good condition, right? But if there is a significant issue after the seller leaves, then you're going to address it. And if it's something that's significant, you're going to get someone to go and evaluate and give you an estimate of what that's going to cost. And the proper procedure here is, you know, you'll get someone to give you an estimate. You have an invoice, you're going to give it to the listing agent. Obviously, you're going to try to have that conversation immediately when you identify it. The seller leaves that day or the next day, the new buyer goes and evaluates and sees that. You immediately want to document. You take photos of it, you document it, and you immediately get someone to give you an estimate, because that was something that we were not aware of. If you get an estimate, and let's say that estimate is, you know, $1,500, well, you know, we didn't know about it. We couldn't have known about it because you had personal items there. And even when we did the inspection, it was hard because the inspector is not going to be moving stuff around just to make sure that the condition of the home is intact. We rely on the seller to provide us that. If the seller knows, you know, hey, I just don't feel right, we need to let the buyer know. Absolutely. As a listing agent, you should, you know, be proactive. And if the seller tells you, well, what do you think? Should we disclose it or not? Absolutely. I'd rather disclose instead of not disclose, and then it comes back to bite you. Now, going back to Christine's situation, that's what I would do. I would, you know, get a opinion of the cost to replace or repair it, and then have a conversation with the listing agent. Look, it was brought to my attention after the buyers went to go and look at the property after your client left, and we noticed a big hole or damage and all that, and we're only asking for this to be taken care of. Now the seller can say, go pound sand again, and says, look, it's not my problem. I close, I'm out. Yeah, that can happen, but also the buyer can go and sue the seller as well. And if the buyer wants to sue the seller, they are within the rights to. They're going to have to articulate and ultimately present their evidence in case why they feel they were damaged and why they feel they weren't properly disclosed, right? And the judge is going to ultimately make the final decision if they have a winning case or not. It's a gamble. It's a 50-50 chance. But that may also push the seller to do something, because I don't want to be dragged into court. I don't want to go through a whole day explaining what was done or what wasn't done or what I should have disclosed or not disclosed. Let's just try to find a medium, right? Let's just work with the buyer. Look, I'm not going to take care of it all. I'll take ownership, but the buyer also has to take some ownership and some skin in the game. I'm willing to split it 50-50. That may be okay. Okay. Now, if it's something super significant and super large, well, that may open up a can of worms. If the seller knew about it and failed to disclose, well, that's a big no-no. All I'm saying. Question? No? Okay. Christine, I hope that kind of answers your question. If she's
Yep,
still there.
Simon, all good. It's in the past, but I just wanted to bring it up.
Yeah. Thank you. Okay, and so thoughts, questions regarding the VP form, kind of how it works, when you use it, and all that fun stuff. And then I'll leave with the final, which is the settlement, closing package is what we close. As a listing agent or as a buyer's agent, you want to be proactive and make sure that you're on top of it with escrow, meaning that you want to make sure that all of the figures and numbers are good, right? And that situation is where you need to, call, email the escrow office, or, hey, can you please provide me with the most updated, right, settlement estimate of the buyer, or if you're working with the seller, the estimate. So that way you can review it together, make sure that there's no additional expenses or charges. Okay, because everything is all an estimate, and as you get closer and closer to closing the deal, especially on the buyer, because the buyer incurs more costs. They got loan fees, right? They got escrow and title fees. And if they also are paying commissions, then, you know, the commission is going to be added to that as part of it as well. It's your job just to go thorough through it and make sure to scrub it, and anything that you catch, you can bring to the attention of the buyer and also the escrow officer, because sometimes, you know, escrow officers do make clerical errors. They forgot to remove something, forgot to add something, and that can change the figures as well. So part of our job, as you know, as we get to the home stretch of closing this deal, is to make sure that we're proactive, but we're also taking care of our client's best interest. And that means, you know, with the buyer and also with the seller. So just keep that in mind, be mindful, be proactive, and, you know, and if you have any questions, always reach out to us. We're here to help and support you. With that being said, I appreciate you all for staying on the call. And if you have any additional questions, don't hesitate to reach out. Have a wonderful Friday and a great weekend, and I will see you on the next contract class, which is in June already. Summertime. Thanks, everyone.
Great,
Thanks,
great
Simon.
class,
This
Simon.
was
Really
great.
Great class, Simon. Thank you.
Hey, everybody.
Thank you very much.
Very
Thank you.
informative.
Thank you. You're very welcome. Thank you very much. Have a great weekend.